Hello everyone. We're just waiting for the last few people to click on the right screen and then we'll be off. So I'd like to introduce myself. I'm Patricia Thomas. I'm the High Sheriff of Herefordshire 2020 and welcome to the High Sheriff's Lecture. I'm absolutely delighted that in these days of the COVID lockdown, this event can go ahead virtually, and many thanks to rural media who are facilitating the process. Daniel Pearce-Higgins will introduce you shortly to our honoured guest, Baroness Hale of Richmond. There'll be time at the end for questions and answers, and you can submit your questions during the lecture via the chat facility down the right-hand side of your screen. Feel free to submit these during the lecture as you think of them. All submitted questions will be made available to Lady Hale, and we will endeavour to get through as many as possible at the end. Daniel, over to you.
Yes, Lady Hale may be familiar to many of you as the presiding judge who in September last year delivered the unanimous decision of the Supreme Court that the government had acted unlawfully in proroguing Parliament. She's had a long and distinguished career as an academic, as a barrister and a judge. Her primary interest has always been in all aspects of family law. And she was the first female member of the Law Commission when she led to the creation of the 1989 Children Act, which created a comprehensive and integrated scheme of court powers for dealing with children cases. It remains in force. Last November in a lecture, Lady Hale concluded that the Act has largely stood the test of time as a piece of lawmaking, unquote. A testament, I would suggest, to her skill as a lawmaker. Another first for her was her elevation to be the first female member of the Supreme Court, originally as a member of the House of Lords in 2004. She has chosen tonight's topic and will accept questions when she's finished. I believe that she always enjoys the question and answer session because she says people ask such varied and interesting questions, especially if they're not all lawyers. As you've indicated, please use the chat box to pose questions and ideally as briefly as possible. Lady Hale, over to you.
Thank you very much indeed for the introduction and the invitation. It's a real pleasure to be with you in Hereford, even if only virtually. I have very happy memories of spending 2 weeks here in the 1990s when I was a judge in the family division of the High Court. I was hearing a case about what was then called Munchausen's syndrome by proxy, whether a mother was making up her baby's illnesses to seek medical attention. The case was very well argued. Counsel for the local authority is now Lady Justice McKerr, a senior judge in the Court of Appeal. And counsel for the mother is now your neighbour, Sir Andrew McFarlane, President of the Family Division. So you can imagine that it was, despite the tensions involved and the sadness of the case, a very enjoyable experience. But sadly, I have never managed to make it back to you in person. So it's good to be here virtually. In the Family Division, we were very well aware that children are real people, each having their own personality, likes and dislikes from a very early age. They are not just the possessions of their parents or even objects of concern for social workers. But even if we know that they are real people, do we really think that they have real rights like other people do? The United Kingdom has signed up to the United Nations Convention on the Rights of the Child, but it has not incorporated its requirements into UK law. The excuse is that much of it is too vague and aspirational to turn into concrete rules of law. But in England, we've not even gone as far as the Welsh, just over the border from you, have done. From very early on, the Welsh Parliament has taken an interest in children's issues. In 2001, it established the Children's Rights Commission in Wales. In 2002, it adopted 7 core aims for children and young people. They should, 1, have a flying start in life, 2, have a comprehensive range of education and learning opportunities, 3, enjoy the best possible health and be free from abuse, victimization and exploitation, 4, have access to play, leisure, sporting and cultural opportunities. 5, be listened to, treated with respect, and have their race and cultural identity recognised. 6, have a safe home and a community which supports physical and emotional well-being. And 7, be not disadvantaged by poverty. Now, these are indeed fine aspirations, aspirations which we might all share, but they need more specific measures to turn them into real rights. However, in 2011, the Welsh Parliament passed a law requiring the Welsh ministers to have due regard to the Convention on the Rights of the Child in exercising any of their functions. Officials have to address their minds to whether a particular piece of work might affect any of the Convention rights, how to prevent breaches, and how to give the rights further effect, and what options and advice to provide to ministers. So, in effect, everything that the Welsh ministers do has to have a children's rights audit. This is very different from the situation in England. I have happy memories of visiting Swansea University for the launch of the Welsh Observatory on the Human Rights of Children and Young People in 2013. There was a delightful presentation from some very young primary school children from a rights-friendly school. This showed that they had grasped the most basic of all human rights, the right to a name and an identity which is recognised by the state. Without that, if you think about it, no other rights are possible. The children had also grasped the basic principle that if one person has rights, then so does everyone else. And so everyone has to respect everyone else's rights. But if we say that children have rights, what do we mean by it? Do we mean that they have the same rights as adults? Or do we mean that they have the special rights of children? Or do we mean a bit of both? I think it's fair to say that we generally don't mean that they have the same rights as adults. I can give you 2 examples. Adults who take part in court proceedings have the right to put their case before the court, either in person or through legal representatives, and to give evidence in support of their case. Article 12.1 of the UN Convention on the Rights of the Child does not go as far as that, but it does require states parties to assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. And Article 12.2 requires in particular that the child be given the opportunity to be heard in any judicial and administrative proceedings affecting him, either directly or through a representative or an appropriate body. Now, our approach to hearing the voice of a child in judicial and administrative decisions which closely affect her is confusing. The Children Act 1989 requires a court to take account of the wishes and feelings of the child, considered in the light of her age and understanding, when making any decision about her upbringing. But this is just one factor in deciding what will be best for her welfare. Local children's services authorities also have a duty to take account of the wishes and feelings of a child whom they're looking after, and when making decisions about the services to be provided for a child in need in the community, and about whether or not to bring care proceedings to protect a child from harm. But they're not always very good at doing this in practice. But at least they have the duty. Things are different in families. Most separating parents don't go to court to sort out the arrangements for their children, or at least they didn't when they could still go to lawyers to do it for them. That is a good thing, because court processes are slow, expensive, and adversarial, and they are likely to lead to less rather than more cooperation between the parents. But how can we ensure that parents take their children's views into account when making their own arrangements? We can urge them to think carefully about what will best suit their children. But we have to be careful about advising them to ask their children what they want. Many children, especially older children, don't want to be asked to choose between their parents, but some do. And if the parents can't agree, they're now expected to settle their differences by mediation rather than by going to court. In private family cases, between husband and wife or mother and father, legal aid is only available for mediation and not for a lawyer's help in negotiating a friendly settlement, still less for going to court. Family mediators no doubt urge the parents to take a child-centered view, and some may even try to involve the children in the mediation, either directly or indirectly. But this is not a professional requirement, any more than it is a professional requirement of the lawyers brokering a deal to do so. So how much are the children's voices really being heard? If the case does go to court, the courts are very reluctant to hear from the children direct. They want to hear their views, but through the professionals, either from CAFCAS, the Children and Family Court Advisory and Support Service, or from expert witnesses. Their reluctance would be understandable if the reason was a fear that if they began to hear directly from children, the services of professionals upon whom the family courts depend so much would be further reduced or even taken away. But in fact, the reluctance to engage directly with children goes deeper than that. Many thousands of children now give evidence in criminal cases every year, but very few do so in family cases, even though these may decide their whole future. We don't like the idea of children giving evidence in our adversarial system of court hearings. We fear that requiring a child to give evidence about the abuse she has suffered could turn the proceedings which are designed to protect her into a further abuse, or that asking about her wishes and feelings in a family dispute will only make matters worse. And we fear that the atmosphere of a courtroom will not help a child to give her best evidence. That is why we prefer videoed interviews. But sometimes there's no option. Where a child is making allegations of abuse against a parent, the rights of all the parties to a fair trial and to respect for their private and family lives have to be balanced against one another, so that sometimes the child will have to give evidence. And some may see this as respecting the child as a real person with her own account to give of what has happened to her. This needn't mean giving the parties a free hand to cross-examine the child in whatever way they think will most effectively destroy her. It may mean a more active role for the judge, and not everyone is comfortable with this. There was a move a few years ago to introduce measures in family courts, like those in criminal courts, which would enable more children to give evidence in person. But these have run into resource problems, like so much else in our justice system. The family judges also have reservations about the halfway house of seeing the child privately. This is partly because they cannot give the child a guarantee of confidentiality and will have to report anything which might affect the result to the parents. This is not a comfortable experience if the parents have no opportunity to question the child about it. But I suspect that for some judges, it's not a comfortable experience anyway. Talking to children about difficult things is not an easy thing to do. And it's even less easy if you don't have a great deal of experience of talking to children about easy things. Nor will the children always find it a comfortable experience. There's also some confusion about the purpose of the child meeting the judge. Is it a public relations exercise, reassuring the child that she's seen as a real person and enabling her to see the judge as a real person and learn more about what goes on in court? Or is it an exercise in helping the judge to understand the child's point of view? If a CAFCAS officer can explore the child's wishes and feelings in private, why cannot a judge do so? Provided, of course, that he or she is suitably trained. When I was a family judge, I would always see a child who wanted to see me, provided that there was someone else present and the child understood that I would have to report back to the adults in court. Of course, I understood that some of them had been prompted or coached by one of the parents, but it was also an opportunity to explain to the child that just as their parents would have to accept my decision, even though they didn't like it, so would the child. So hearing from the child is one example of how we don't think it's good for children to have the same rights as adults. Another example is medical treatment. Adults can decide whether or not to have any treatment, including life-saving treatment that their doctors advise. But what about a child? Here again, our law is pretty confusing. On the one hand, there is a section in the Family Law Reform Act 1969 which states that the consent of a child aged 16 or 17 to surgical, medical, or dental treatment is as effective as if she were 18. And if she's given an effective consent, it is not necessary to obtain the consent of her parent or guardian. In the well-known Gillick decision in 1986, the House of Lords decided that a child under 16 could also give a valid consent to contraceptive advice and treatment, as it happened, provided that she was able to understand the issues. Lord Scarman said the principle was this: as a matter of law, the parental right to determine whether or not their minor child below the age of 16 will have medical treatment terminates if and when the child achieves a sufficient understanding and intelligence to enable him or her to understand fully what is proposed. Note the or not. So what of a child who is old enough to understand the issues and says no? You may have read Ian McEwan's novella, The Children Act, or seen the film version starring Emma Thompson. Both of them remarkably accurate. They're all about a 17-year-old Jehovah's Witness child of Jehovah's Witness parents who refuses his consent to a blood transfusion which the doctors think necessary to save his life. In that case, neither the child nor the parents wanted the treatment. But what if the parents want it and the child does not? The Family Law Reform Act also says that nothing in the section renders ineffective any consent which would have been effective had the section not been passed. So if the law recognized the parent's consent as effective, this would be enough. But the logic of Lord Scarman's statement is that the parents lose the right to decide either way on medical treatment once the child gains that right. However, there were two cases decided in the 1990s where the Court of Appeal held that the High Court could override a young person's refusal and authorize life-saving treatment in her best interests, irrespective of whether she was Gillick competent, as we call it, to make the decision for herself. In one of them, the court authorized the compulsory use of antipsychotic drugs to treat a 15-year-old suffering from increasingly paranoid and disturbed behavior. In the other, it authorized the compulsory treatment of a 16-year-old in a dangerously anorexic state. The Master of the Rolls, Lord Donaldson, also said that anyone with parental responsibility for a child could authorize doctors to carry out much needed treatment, despite the child's own clear opposition, whatever her age, over or under the age of 16, and whether or not she was Gillick competent. That was just a remark. The other judges didn't agree with it, but it has been frequently referred to since. But it is one thing to allow a court to override a child's decision after a fair hearing in which all sides of the argument have been properly ventilated, including in Ian McEwan's fictional example, which is based on a real case, going to see the child in hospital. It is another thing entirely to allow a parent, or worse still, a local authority with parental responsibility, the right to force unwanted treatment on a protesting child. But since these decisions, of course, we've had the Human Rights Act. This protects many fundamental rights, including the right to personal liberty, the right not to be deprived of that liberty without a good reason and proper judicial safeguards. Last year, the Supreme Court held that it was not within the scope of parental responsibility for a parent to authorise the confinement of a child, that's the deprivation of a child's liberty, beyond what it would be normal for a child of that age, even if the child was not competent to make the decision for herself. This was in the context of the residential placement of a 16-year-old boy with a number of mental health problems. But still less would it be possible for parents or others with parental responsibility to authorise the confinement of a child who was competent to decide for herself. Now, that case was about treatment and care in a residential placement, but it is quite likely that the same reasoning would apply to other forms of medical treatment. So it may be that parents do not have the right to force treatment on children, which will be a breach of the child's human rights. The matter would have to go to court. But if the case does go to court, how should the court decide it? Not, it seems clear, in accordance with the wishes of the child, even a child who is mature enough to make the decision for herself, but in accordance with the best interests of the child. Her wishes and feelings play an important part in deciding what is in her best interests, but they don't decide the issue. So here are two contexts in which we recognise that a child does have rights, but they are not the same as adults' rights. Even if the child is old enough to understand the issues fully, her wishes can be overridden by what the court thinks is in her best interests, as happened with the 17-year-old boy in the Children Act. This attitude of the civil law is in stark contrast to the attitude of the criminal law towards the responsibility of children. In England, the age of criminal responsibility is 10, one of the lowest in Europe. Not only that, in 1998, the rebuttable presumption that a child under 14 was incapable of having the guilty mind, which is an essential element of most criminal offences, was abolished. The child's level of understanding doesn't come into it. Now, many bodies have called for the age to be raised, but the government has rejected this, arguing that setting the age at 10 allows frontline services to intervene early and robustly, preventing further offending and helping young people develop a sense of personal responsibility for their behaviour. Well, that's fine, but it all depends upon what happens when a child does offend against the criminal law. The Children's Rights Alliance for England has argued that there's still no real distinction in law, policy and practice between how the state responds to adults and to children who are in conflict with the law. The law still includes punishment as well as reform and rehabilitation amongst the aims of sentencing for children. It doesn't provide that custody is a last resort, and that if resorted to, it should be in a secure children's home rather than a penal service establishment. And it continues to allow children to be tried in adult courts. That's what the Children's Rights Alliance argues. And in the first decade of this century, we went through a phase when more and more children were brought into the clutches of the criminal justice system. The government restricted police discretion to issue reprimands and cautions and gave them targets for offenders brought to justice, all of which pushed more and more children into the youth justice system, where they rapidly climbed an escalating scale of responses. There was an explosion in the numbers of children in secure institutions. Fewer and fewer of these were sent to secure children's homes, which are much better suited to their educational and developmental needs, and more were sent to secure training centres and young offender institutions, which are part of the penal system. These institutions raise many children's rights issues. Children die in them. Physical interventions are used in them, theoretically only as a last resort, but, for example, to prevent a child doing harm to herself or others. What other purpose might they have? The authorised techniques include those which deliberately cause pain to the child, which is obviously capable of being perceived as physical punishment, although this is banned. The education and training available in them has also been found wanting. Happily, however, the use of custody has declined sharply in recent years, from over 3,000 in 2003 to under 1,000 in 2017. And most of this decline has been in the use of young offender institutions, which must be a good thing. The vast majority of children in custody are boys over 14. Worryingly, however, more than half are of BAME heritage and 28% are Black. And there is an upward trend in restrictive physical interventions where physical force is used to overpower the child. But there's also been a huge drop in the number of children entering the criminal justice system. In the year ending March 2019, there were over 60,000 arrests of children. 8,500 children were given a formal police caution. 27,300 were taken to court, and 19,300 were sentenced. So a total of 21,700 children were cautioned or sentenced, less than half of those arrested. And this has fallen by 83% over the last 10 years. I don't suppose this means that children are behaving any better than they used to do. What it means is that the criminal justice system is getting its teeth into them rather less and rather later than it used to. And this must surely be good news. The bad news is that Black children are overrepresented amongst those arrested, those cautioned, and those sentenced. But perhaps overall, we are coming closer to the aspirations of the UN Convention on the Rights of the Child. The right of every child alleged as, accused of, or recognized as having infringed the penal law to be treated in a manner consistent with the promotion of the child's sense of dignity and worth, which reinforces the child's respect for the human rights and fundamental freedoms of others, and which takes into account the child's age and the desirability of promoting the child's reintegration and the child's assuming a constructive role in society. That's Article 40.1. All sounds good, doesn't it? But it's not only children who've infringed the criminal law who need to be brought up to assume a constructive role in society. We recognise that children have rights which adults do not have. Perhaps not all the rights which the Welsh Parliament might have wanted for them, but definitely the right to be looked after and the right to be educated. The UN Convention recognises the right to education, and among the aims of that education, the preparation of the child for responsible life in a free society. The only article in the European Convention on Human Rights, which is part of UK law, which looks like a positive right to be provided with something, is Article 2 of the first protocol, which begins, "No one shall be denied the right to education." I'm afraid that I lost my battles to persuade my colleagues in the Supreme Court that the best interests of the children involved had not been treated as a first priority, as required by Article 3.1 of the Convention, the UN Convention, by the government when it devised the benefit cap, which deliberately pushed children below subsistence level. But I narrowly won the battle to persuade them that it was unjustified discrimination against children who'd arrived here with their parents at an early age and lived and been educated here all their lives, to deny them student loans because they didn't have indefinite leave to remain, their parents never having regularized their immigration status, no fault of the child's. The European Court of Human Rights had said that, unlike other public services, education is a right that enjoys direct protection under the Convention, and it not only directly benefits those using it, but also serves broader societal functions. In other words, we all have an interest in the proper education of the next generation. Which brings me to your High Sheriff. She too believes that children have a right to education, but the education to which they have a right must be an education which equips them to take on the responsibilities of adult life. And this must include basic employability. Not only the knowledge and skills required to do the job, but also the willingness to turn up on time, to dress appropriately, and to accept direction from those in charge. I agree with all of that, of course, although I also believe that employers have a duty to treat their employees properly, to make clear what is expected of them, to provide training and development opportunities, and not to make unreasonable demands of them. So yes, of course, children do indeed have rights, and especially the right to be treated as individuals and with dignity and respect. But mostly their rights boil down to being provided with what we think is best for them, rather than with what they want. Probably all to the good. Thank you.
Patricia, do you want to start off, or shall I start off with questions?
If you'd like to start off, Daniel, that would be great.
Right. Lady Hale, you raised an overall topic of the use of the legal system to protect children, establish their rights and look after them. Slightly contentiously, I think, arising at the moment is the extent to which, I think it's proposed in Scotland, that any sort of physical chastisement of children will be made unlawful. Is this a good use of the legal system? I mean, even if one thinks that any physical abuse of children is to be deterred, is it a sensible use of the legal system to make it an offence for any parent even to use reasonable chastisement, physical chastisement of a child?
Well, you're right that that's a hugely contentious issue. I think that Scotland has done it and that Wales wanted to do it. And maybe the wisest thing for England to do is to learn from their experience of that. Whether in fact it has improved matters for children, whether it has made matters worse, which is unlikely, and whether it proves in the slightest bit sensible to try and enforce it. But I myself believe that children should not be hit. Adults mustn't be hit, and I don't think that children should be hit. But I would distinguish that from necessary measures of physical intervention to prevent them doing harm to themselves or indeed to others. So of course you stop a toddler running into the road. Of course you do that sort of thing. But that's my personal belief. Whether it's a good idea to turn it into a rule of law is another matter, as I was saying. Let's see how it works out in Scotland.
Thank you, yes. Tricia, you want to...
Yes, we have a question here from Jeremy Wilding, our under-sheriff. How does a judge deal with the heavy responsibility of making decisions about a child's future? Can there be any more weighty duty for a judge to perform?
Well, I'm sure that your fellow chair would agree with me that there is no weightier duty for a judge to perform. And there are a lot of judges who don't do family cases who say, oh dear, I couldn't do that. But it's like every judging job that there is. You have to hear the evidence. You have to listen very carefully to the evidence. You have to try and understand the characters and personalities of the people involved. You have to try and understand the child involved as well. Despite all the problems of how you find that out, you do have to try and look at the child as an individual and work out what is best for that particular child. And like all judging jobs, once you weigh up the evidence and the arguments, you tend to be able to reason your way to a solution. It's not easy, but it tends to be possible. And sometimes, of course, you would like everybody else to behave better for the sake of the child. And that's the most difficult aspect of it, because people aren't always as well behaved in relation to their children as you would like them to be. I don't suppose any of us is.
I can just add to that the small amount of family work I used to do was always interesting and challenging, but and a burden to make difficult decisions. And I was glad I wasn't doing it as the only jurisdiction I dealt with. I think the judges who deal only with family work, it is a real heavy burden and difficult to sustain.
Yes, I agree with that. And in fact, I think that nobody should really be asked to do it all the time. And a variety of judging work is beneficial in my view.
I think Jeremy Wiley is also concerned about the extent to which judges are aware of different social backgrounds, different cultures from which in our multicultural society people come. Do you want to say a bit about perhaps the training of judges on this?
Well, I'm afraid it is a very long time since I went through my judicial training, because it's a very long time since I was a trial judge. I've been an appellate judge since 1999. So I'm not really up to speed on this, but I would very much hope, I know that there's something called the Equal Treatment Bench Book, which tries to explain to judges different cultural traditions and things that they really ought to try and understand when they're dealing with all sorts of different types of backgrounds. It's not just ethnic backgrounds, or religious backgrounds, it's others as well. But of course, there is always a bottom line, which is that we're trying to protect children from suffering significant harm. It may have been the practice in the upper classes to send their children to prep schools where they were routinely beaten. It would be our duty to protect children from that sort of harm these days, wherever it came from.
Yes, Patricia.
Thank you. We've had a question from Liz Griffin, thanking you for a remarkable lecture. And she hopes that this isn't outside the remit, but what are your views on a treatment in England of child refugees?
Oh, yes. Well, if an unaccompanied minor arrives and asks for asylum, well, then the local authority will take responsibility for them until the asylum application is decided. Although the normal practice, as I understand it, has been to give them leave to remain here until they're nearly 18, rather than decide their asylum application. And some people think that's controversial because there could be children who've got a genuine asylum claim, and it would be very much in their best interest to have that decided when they make it, rather than put the whole thing off until they're 17 and a half, which has tended to be the practice. But we did hold in the Supreme Court that practice was lawful, so I can't say that it's unlawful to do it that way. One of the big problems is actually deciding whether the child is a child. Because obviously, if you have got a teenager, and a teenager who doesn't come with documents, or whose documents are not necessarily reliable documents, how can you determine whether that person is under or over 18, which is the cutoff point for this purpose? So this is difficult. And, we did hold in the Supreme Court that the adjudicators have to decide whether somebody's a child. It's not something they can just let the authorities decide, but because it dictates the child's whole approach to the child. But it's not easy. There's no simple way. It's not like dating trees.
Daniel.
There's a question from Dr. Mike Cohn, who's a gynecologist, who asks that with Gillick competency, is there an agreed standard as to what understanding, quote unquote, is? Sometimes, he says, children can appear to be competent, but are they really?
Well, that's true of adults too. But we assume that adults are competent, whereas with children, we put them through various hoops. We shouldn't ask too much in the in asking whether they are competent. We should ask for a basic understanding of what is involved and the pros and cons of what is being proposed, because otherwise that would have knock-on effects for people, adults with possibly less learning ability than others, and who need to be given the agency to make decisions for themselves. So.
I think one has to add, of course, that competency is issue specific. So it depends what the what issue is. There's not a sort of general competency or not.
Absolutely, it is. And you can decide what to have for tea when you may not be able to decide to have complex surgery.
Tricia.
Thank you. Sue Furnival has asked, the title of your lecture is The Rights and Responsibilities of Children. I wonder what responsibilities you consider that children have.
Well, one of my reasons for mentioning the criminal justice system, of course, was that puts responsibility on children to behave themselves, and it puts it on them really quite strongly in circumstances where they may lack the understanding which they need to be able to exercise free will and judgment in other areas of life. So that's one thing. Children obviously have the responsibility to obey the law. They have the responsibility to go to school. And I think their biggest responsibility is actually to themselves, in the sense that they should be looking to make the best of themselves and their education so that they can enjoy a happy, healthy, and productive adult life, which is part of what I was trying to say.
But that's not actually written down anywhere.
No, it's not written down anywhere. No, it isn't.
Okay, thank you. Daniel.
Well, one aspect of that, if I can interject, is the question of the age of consent. You talked about the age of responsibility for crime. Another aspect of that is the age of consent to sexual activity, which again, I think there's suggestions it should be reduced from effectively the age of 16 to something rather lower. Did you have any views on that?
I think that's a really difficult question because it is currently 16, but it's ridiculous to think that young people under the age of 16 aren't going to engage in certain levels of sexual activity. And the question is, does it make it easier for a reluctant child to say no if, in fact, it is against the law, even though in practice it's not going to be proceeded with unless the results are difficult? I do find this a difficult question because you need to have an element of practicality, but you also need to have an element of protection for those who would like to be able to say no. And I feel this particularly strongly now when young people are subject to so much pressure to engage in sexual activities that they may not wish to engage in. And young children are bombarded with sexual images and sexualized clothing and other sorts of things, which really does worry me. People should be free to engage in sexual activity, but when they're ready for it and not before.
Yes, Tricia, do you want to pick up on question number 7 there?
Can do. Yes, I can. Catherine Smith says it's disappointing that children and young people cannot be more directly involved in court procedures. I've always found that with training and support, children and young people can make a very sensible, passionate and honest contribution.
Yes, well, I think it must be apparent from the way I was explaining things that I share that view.
And she adds that, is there a way that the court system and the processes can be made more accessible and less intimidating?
Well, of course. It can be done. These things can always be done with will and with quite a lot of training and experimentation. It is standard practice in Scotland for the judge to see the child. At least I understand that it's standard practice. I was told that it was. And yet in England it is regarded with very considerable trepidation. And I must admit, there is one notorious case in which a judge did see a child and subjected the child to an extremely intimidating cross-examination, which of course should never have happened. But the fact that something goes wrong when it is done doesn't mean to say that one shouldn't try and do it and find ways of doing it. I quite agree that I don't think a child should be forced to come to court and have their say if they don't want to. But if they do want to, with suitable training and adaptation, it seems to me it would be a good thing to try and do. But we've got an awful lot on our plate in the family courts as well. So I realise that I'm asking for the moon.
I suppose that does always raise the question of resources. I mean,
Yes.
the lack of legal representation in private family proceedings is something of a view on, I imagine.
Yes. Well, there are, as I said, that they had hoped to be able to introduce something similar to what goes on in criminal courts when children are witnesses, but that's a resource question as well. Plus the lack of legal representation.
Generally, on the question of the question about the transparency, I think picking up what Sir James Mumby has said in the past about the need for greater transparency in family courts, does that in any way conflict with your view about the protection of children or the rights of children?
Well, I think one's got to. This is definitely a question of balance. Open justice is an extremely important principle. It keeps us in order. It makes sure that we are behaving properly and in accordance with the law. It also has an educational function. It tells everybody, or not everybody, but anybody who's interested, what we're doing and why we're doing it. And so the general principle ought to be open justice. But at the same time, of course, family cases involve the private lives, not only of the adults, but also of the children. And so the best sort of compromise, it seems to me, is that one lets people come in from authorized representatives of the media, but restrict what they can report about what they have heard. That's a difficult thing to do because it's very, very important to avoid reports which will enable the jigsaw identification of children, putting together bits and pieces of information about the child, which will enable it to get out in the child's social circle that what's been going on. That would be, I think, very harmful. Certainly the children don't want it. All the evidence that there is about the views of children is that they don't like publicity being given to their cases in a way which would enable them to be identified. So it's a question of trying to balance those two considerations in a sensitive way.
Thank you. We've got a rush of questions now. I think the shyness has fallen away, and I've got one here. I'm going to go with this one because it's from my brother. So Chris Behag asks, some religions do not allow medical procedures, the Jehovah's Witness and blood transfusions, for example. Are there occasions when religious or cultural traditions might be contrary to the court's wishes?
Well, yes, and we have long taken the view in relation to the particular example that you mentioned, that in the last resort, the court will authorize it even if the parents oppose it, as long as all sensible alternatives have been tried. So the court's principle is what is best for the child, and the court takes the view, I think almost invariably, that the child's life must be preserved until the child is grown up, and similarly with serious risks to the child's health. I say almost always takes that view. There are, of course, cases in which the child does not have a life, and it's only being kept alive by extraordinary medical efforts, which the parents wish to see continued, but the court has decided on the medical evidence is futile. So not easy.
There are a number of questions raising with the issue of the lack of resources and the training that judges get. I mean, I suspect that in your elevated position, that the lack of resources is probably less apparent than at the front line, as it were. I mean, are you optimistic about what's happening? What particular changes would you like to see?
Well, I would like to see public funding restored for legal help. Not so much for legal representation in court, but for early intervention to enable families to sort things out, because that's what used to happen. You know, the job of the family lawyer was to enable the client to understand what the court would be taking into account, what was likely to be the outcome, and to help to do agree the arrangements with the other side. That's what they were for. That's what they did. And the problem is that now they're not able to do that for both sides. You've either got an imbalance where one side has got a lawyer and the other side hasn't, which is obviously a real risk in family cases and not at all a good thing. And you can't reach an agreement as a result of that, or neither party's got a lawyer, and cases have to go to court because they can't work out things for themselves. It's unreasonable to expect people to work out things for themselves. I mean, they don't know the boundaries, they don't know what's available, they don't know what the court's going to think about, and it's really difficult for them to do so. So many more cases are coming to court, are they not? And in many of those cases, people, one or both sides, are without a lawyer, and that makes it a much more difficult job for the judge. Sometimes one finds, I don't know whether you found this, that sometimes cases involving people who are representing themselves went on longer than they otherwise would for all sorts of reasons. But sometimes they actually went on less time than they should have done, because the person representing themselves didn't really know how to put the case before the court. And there are limits to what the judge can do to drag it out of them. Although I think the techniques which we learnt when we were in tribunals are now more and more having to be used in courts.
Yes, undoubtedly, the self-representing clients present the judge with an even greater burden than those with representation. Mm. Do you want to deal with perhaps this last question?
Gosh, we've got a whole load come in now. What would we could?
I think many of them are covering what's really been covered.
Yeah, I mean, there is one here that from Julie Cohn that says, do you feel that children with special needs are given an appropriate voice within the court system?
Probably not. It does depend. Obviously, we think that the voice in family cases should be done through CAFCAS or expert witnesses, but usually CAFCAS. And one hopes that the CAFCAS officers are sufficiently skilled to be able to deal appropriately with children with special needs. I think there's probably a much greater worry about the criminal justice system and children with special needs, because I have the impression that children with various sorts of special needs are overrepresented in the youth justice system.
Thank you. Right, so we've got in the last few minutes, have we got time for any more questions? What's the verdict, everyone?
Yes, I think perhaps number 16 there.
Okay. Right, shall I go with that one, Daniel?
Yes, why not?
Yeah, what is your opinion of the family drug and alcohol courts and their engagement with families to change?
Yeah, well,
Catherine Smith.
Well, obviously, I have no direct experience because it's such a long time since I was on the ground in the family justice system. But these were pioneered by District Judge Nicholas Crichton in London. And basically they were doing their utmost to mobilize services so that people who were having problems with drugs and alcohol could be helped to get off them, and so that they could keep their children. And it was an effort of keeping track of the case, bringing it back regularly, mobilizing the services, seeing how things were, so that the children could either stay with or be returned to their parents. All the evidence I have seen about it was that it was extremely successful and a very good thing.
Right, so we're just about coming up to time now, and it's up to me now, Lady Hale, to say thank you. To have such an eminent speaker to deliver the Shrevell Lecture in Herefordshire will be remembered for many, many years. And the choice of topic has been, it's so complex, and it's given us lots to think about and consider. I was really thrilled earlier when you answered agreed to my request, and when it became necessary to do this virtually, I was thrilled again that you are so apace with modern technology that this webinar has been possible. There are few events that have benefited from the pandemic, but this webinar will reach the lecture being delivered by webinar means that it'll reach a far wider and more diverse audience than if the event had been constrained by a capacity of a venue. So I want to again say thank you very much for your time, the choice of subject, and for your technical know-how. Thank you.
Well, and thank you for the invitation. It's been very enjoyable, and I'm only sorry I can't be with you in person.
Well, we'll have to get you here.
Yes.
At some point. That would be lovely.
My thanks to that. I think I'm right, Tricia. This is going to be recorded. This has been recorded, and will be available.
Yes.
Those who want, who weren't able to hear all or part of it, so it will be available as a recording to listen to in the future for those who want. Yes. But thank you also.
Before we close, I know some people have had some difficulties donating to the Hereford Cathedral Perpetual Trust during the registration for the event. If you'd like to donate, there will be a follow-up email coming to you, everybody who's participated. And so the link will be in there, and I know any donation will be gratefully received. So we actually had 167 people register for this event just before we started, which was amazing. I was absolutely fantastic. And I hope you all enjoyed it, and thank you very much for attending. So all that's left for me to say is from Baroness Hale of Richmond, the Honorary Recorder of Hereford, the good people at Rural Media, Glyn Morgan from the Cathedral, and me, the High Sheriff, we wish you all good evening.
Good evening.